Now we are here because our clients, the Supreme Egbesu Assembly, has dragged the federal government to court, in specific, the National Assembly, on two issues. Now, one of the issues is the creation of additional local government areas for Bayelsa State. You will recall with me, you agree with me that sometime in 1999 to 2000, the government of Bayelsa State, through the State House of Assembly, created additional 25 local governments. And that law is still before the National Assembly. And now they have written to the National Assembly for consideration that indeed Bayelsa just had just 8 local governments, which is very unjust, unfair, and against all principles of justice. It is on the strength of that, in recognition of the Constitution, particularly Section 7, Section 8, Section 6 of the 1999 Constitution, as amended, that provides for the procedures upon which state local government can be created. And one of such criteria is that the State Assembly will have to sit and consider the creation of local government. Now, once the State House of Assembly do that, they transmit same to the National Assembly for consideration. You agree with me that Bayelsa State has met that condition precedent for the consideration of the creation of additional local government. Now, we have written to the National Assembly. We expect that the National Assembly should honor our letter and discuss on it. But they didn't do that. So we are here in court asking the court to mandate the National Assembly to deliberate on what the Bayelsa State government has done and create additional local government for Bayelsa State. If you know, which I believe you know, that Bayelsa is just 8 local governments, which is the smallest among all local governments in the Federation. And Bayelsa is the father of economic success as far as the nation is concerned. So we are asking the courts to compel the National Assembly for the creation of additional 25 local governments for Bayelsa State. Now, that is one. On the other issue is the issue of resource control. In other words, means true federalism. Now, you will agree with me that Nigeria is a federal system. And the principle of federalism, as practiced all over the world, entails that state governments should control their resources and pay an agreed percentage to the center. You cannot come to control my resources and give me what you want. You know, that is the issue. You cannot come to my own state, you collect everything, and then you dip your hand inside pocket and say, you take this. That's an aberration to the principle and tenet of true federalism. And so what we are saying is that Nigerian government should respect the practice of true federalism by allowing states to control their resources and pay an agreeable percentage to the federal government. That practice was age-long. In fact, if you look at the 1960 Constitution and the 1963 Constitution, that was the practice. But when you look at history, you find out that the laws, as far as Nigerian law is concerned, is a borrowed law from the colonial government. Why do I say so? When the British Empire came into Nigeria, the 1860 secession treaty simply gives all the resources, all the economic powers and everything to the Queen and Majesty. And that is where our own government derive such colonial powers. We are saying that we cannot agree to such powers. And so that provision of Section 164 of the 1999 Constitution should be abolished. It should be removed completely and allow state government to control their resources and pay agreeable percentage to the federal government. That's why we are in court. Well, this resource control struggle is age-long. It predates even we that are fighting for it. When you talk about bottleneck, I could recall sometime in 2000 when the issue of onshore-offshore dichotomy case was before the Supreme Court. And the Supreme Court says it can only be resolved politically. Now, the bottleneck is the National Assembly. When I say the National Assembly, Nigeria and its people should look at things from the side of justice. If they say we are one, then that oneness should be beyond all ethnic interests. It should be for the interests of the people of Nigeria. And the Job people are the people of Nigeria. Bayelsans are the people of Nigeria. Niger Delta are the people of Nigeria. Even the North are the people of Nigeria. And if we recognize this true fact, then there shouldn't be any bottleneck as to the practice of federalism. In fact, what we are doing even favors the North, the South, and the East, because the North also have their own resources. The South has their own resources. The West has their own resources. Also, the East. Every part of the Federation has their own resources, except otherwise that some very few, microscopic few, are indeed wielding the powers of the federal government to undo some other people. If not, what is so difficult for the issue of resource control? I don't think there's anything difficult in it. Yes, the defendant has been served. Now, in law, what we serve is an originating summons. An originating summon process takes 21 days. The defendant is still within time for which they can file their responses. And that's why the court has taken this long adjournment to enable the time elapse. So the dates that the case has been adjourned to is on the 1st of June. By then, their time to respond has elapsed. And if they fail to file, then the court knows what to do. We know what to do, and the court also knows what to do. Thank you very much. Yes.
Yeah, we are in court because of two vexing issues affecting the whole of Ijaw land. One of them is the issue of creation of local governments in Bayelsa State, and the other one is resource control by our people. That's why we are here today. We have been on it for some time, and as you know, the issue of resource control is an issue that our fathers were fighting for, and they are gone. We have taken over, and we want it to end. We can't be doing things the same way and not achieving results. We are even, by coming to court today, we are even doing Nigeria a lot of good. Because before now, you know how we, the Ijaw people, we will do our things. All the rest of the Nigeria will do our things. We go out there, we close down flow stations. There will be so many to affect the economy. But coming to court today, we are doing Nigeria a lot of good because we don't want that to happen. And Nigeria should listen to us and do what is right.
What do you think is right, sir?
What is right is to allow the people to control their resources. Not only the Ijaw people. We are fighting for resource control for Ijaw people, but we know that there are resources in other parts of the country. And we also know that some communities, some tribes are quietly mining their resources, e.g. gold. And even minerals like tin and all other minerals, they still mine them and do as they like. But when it comes to oil, it's different. It's a different ball game, and it's not good for us. It's not good for us. So we are doing this so that we will be able to control our resources. And on the issue of local government, it is very, very unfair. You create a state, you give them only 8 local governments. And you know, Bayelsa is the capital of Nigeria. I am not from Bayelsa, but I am here on this matter because I pay tax here. Most of us from outside Bayelsa, we are here. It's the capital of Ijaw land, and when things are good here, it cascades to the rest of Ijaw people. So we are fighting for more local governments because how can states like Kano have 44 local governments and they have 44 House of Reps representatives? Bayelsa, we have 8. We are not even giving 8 House of representatives. It's only 5. It's unfair. So give us more local governments. We have met all the criteria for having more local governments. They said there should be it should be passed by the House of Assembly. There should be what they call acceptance by the people. All of it have been done. Assembly has approved during the time of Alemnisia, but yet they didn't do it. And we have waited and waited for this long. And the injustice is getting much because so many things are shared based on local government areas in this country. And we provide, Bayelsa State and the rest of Ijaw land, provide the bulk of the wealth that is sustaining Nigeria. We can't be sustaining others and we are having less. It's unfair. We are members of the Supreme Egbesu Assembly representing the whole of Ijaw land. We are Ijaws fighting for resource control and more local governments for Bayelsa State.